Let's get started. First of all, thanks for coming to this lecture, and thanks to the foundation for giving me this award. When my colleague, Tim Armstrong, talked to me about the prize, he said, the prize comes with a fun part, which is the short lecture. So naturally, I asked him, can I keep the prize, but skip the fun? And the answer is obvious, since we're here today for the fun, all right? So let me share with you one of my recent research projects. Actually, the project is indeed fun in a way, because when I started this project, I had a different intuition about the outcome. And then through research, I completely changed my mind. My research benefit from my two research assistants, Deborah, who's in the audience, as well as Daniel, who is sitting right there. And actually, we filed, the three of us filed a SEC comment letter based on this project a couple of weeks ago. We're yet to hear from the SEC. This project is about the SEC's failed effort to enhance transparency for stock repurchases. A bit of background here. Public companies buy back their shares from the open market from time to time for different reasons. For example, management may say that we believe the shares are undervalued, and therefore it is time for us to buy them back while they're cheap. Or the company may have an exceptionally good year, and the company wants to return capital to the shareholders, but the company does not want to disrupt its normal dividend policy. And the company can choose to return capital to shareholders through stock repurchases. Or the company may say that we buy back our shares as a way to fine-tune our capital structure. We can borrow money and use the proceeds to buy shares so that we can increase the debt a little bit and reduce equity so as to change the debt-equity ratio. Or the company may say, we expect that our convertible bonds will be converted in the near future, or our employees are going to exercise their stock options. And for these transactions, we expect to issue additional shares, and that is going to create a dilutive effect to our existing shareholders. And to neutralize that dilutive effect to some extent, we want to buy back shares from the company. So these are the common reasons given out by management for their open market buyback activities. But the SEC is more concerned about the hidden motives behind the buybacks. For example, the SEC is concerned that the company may use buybacks to window dress earnings per share. Earnings per share is a important performance measure of the company's well-being. So the EPS is given by earnings divided by number of shares outstanding. When the company goes to the market to buy back the shares, they're reducing the shares outstanding and therefore inflating the earnings per share. Or the stock buyback may be motivated by price manipulation. For example, the company may be in the middle of a merger negotiation, and the company's value is closely tied to its market price. Or the company's executives may expect their compensations will be determined in the near future, and the compensation committee looks closely to the stock market performance. Or management may try to condition the market through buybacks shortly before they sell their own holdings. Okay, so the SEC is concerned about these hidden motives and decides to regulate it through enhanced transparency about stock repurchases. Here is the timeline of the SEC's attempt. Late 2021, the SEC proposed new rules, and then after an extended period of market consultation, the Commission adopted the final rule in May 2023. And then literally days after the SEC's adoption of the new rules, the U.S. Chamber of Commerce filed a lawsuit against the SEC in the Fifth Circuit, claiming that the SEC adopted new rules without showing clear benefits to investors, and the SEC demanded reporting of information that is either immaterial or redundant given the existing regulatory structure. And at the same time, these additional reporting requirements add cost to the companies. In the end, the Fifth Circuit sided with the chamber, ordering the SEC to provide a comprehensive cost-benefit analysis within 30 days. And this, the Commission felt like it couldn't deliver. And therefore, toward the end of the deadline, the SEC announced that it was suspending the implementation of the new rules pending the completion of a cost-benefit analysis. There are two opposing views about the SEC's new endeavor. On the left panel, I'm listing a few influential institutions that basically sided with the U.S. Chamber of Commerce in claiming that the SEC failed to show clear utility of the new regulations. But on the right panel, I'm also listing important institutions that urge the SEC to repropose this rule for the benefit of investor protections. And the list also includes certain senators. But in order to assess the utility of the SEC's new regulation, we need to compare the existing rules with the new rules, of course. Under the existing rules, companies are required to report their buyback activities, but on a quarterly basis. And the information provided takes the form of the aggregate number of shares that occurred, that were bought back during a given month, and the average price paid during this month. The companies are also required to report whether the buybacks were subject to the safe harbor protections of Rule 10b-18 and 10b-5-1. These two rules required some explanation. Rule 10b-18 provides a safe harbor against market manipulation claims if the buyback activities follow the stringent requirement of the SEC in terms of the timing, the quantity, the price, and the manner of conducting the buyback. So basically, if you follow these rules, the SEC said, we're not going to be knocking on your door for market manipulation. Rule 10b-5-1 plans deal with the concern of insider trading. So such plans are pre-arranged plans implemented at the time when the company and the executives are deemed not to possess material non-public information. For example, the plan may say something like, in the next 6 months, every Monday, the company is going to buy back its shares at the then prevailing market price. Okay, and with the plan in place, share buyback activities are no longer in the discretion of the executives and the board. They're pre-arranged, and by the time if buyback activity scheduled buyback activity comes, then orders will be placed automatically in the market. What do the new rules do? The new rules, while also requiring quarterly reporting, okay, but change the monthly aggregate buyback data to daily repurchase data. So with the new rules, the SEC requires the companies to show that during this reporting period, buyback activities on any given day and the average price that the company paid for the buybacks for those shares. And the SEC also required the companies to specify the reasons and rationales behind the buyback decisions and the criteria for determining the quantities of the buybacks, and as well as the corporate policies for insider trading during the repurchase period. Under the existing rules, insiders are required to report their trades. Okay, if they trade the company's shares, they're required to report the trades on Form 4 within 2 business days with the SEC, and the new rules do not change anything in that regard. The new rules were subject to a lot of criticism. To those criticism, the SEC responded by saying this: look, we're providing you with the daily data. Okay, with that daily data and also with the insider trading reports, you can have a clearer link between these 2 dates, and also with the information as to whether the buyback activities fall into the existing safe harbor plans. All these information put together can allow investors to readily spot suspicious buyback activities. However, the SEC failed to elucidate on how investors can utilize the additional insights to hold management accountable in court. So what exactly are the benefits of that insight? Okay. Enhanced disclosures, generally speaking, have 2 goals. One is to guide investors in their short-term investment decisions. So in that regard, the new rules wouldn't do anything because the new rules require quarterly reporting. And by the time that the information is reported, days or even months have already elapsed, and the investors couldn't do anything based on the information reported in terms of their investment decisions. But then the next goal of an enhanced reporting is really to empower investors to hold management accountable for wrongdoings at court. So if there's any benefit that comes from the SEC's enhanced disclosures, it would have to focus on whether they can empower investors in court. Potentially, okay, there are a few claims that are available to investors when they suspect that the buybacks were motivated by management's self-interest. There is potentially a state law claim for fiduciary breach for committing corporate waste. And then there are also a few federal securities laws claims potentially available to the investors. And I'm going to talk about these claims one by one. First of all, let's look at the fiduciary breach claims for corporate waste. Now, directors owe a fiduciary duty directly to the corporation itself, not directly to the shareholders. And therefore, a fiduciary breach claim technically belongs to the corporation. And because the corporation acts through directors and officers, when shareholders want to sue for fiduciary breach, the first step really is for the shareholders to demand the board to take action, unless the demand is excused, because it would be futile to make such a demand because it's clear that the board wouldn't take any action. So to prove demand futility, investors can show that the directors derived personal benefits from the challenged activities, or the directors face a high likelihood of liability from the challenged activity, or Even if the directors do not derive personal benefits or otherwise face high likelihood of liability, they may lack independence from those people who indeed derived personal benefits or likely face a high probability of liability. So with regard to pleading demand futility, I think the SEC's new rules can help investors at least to establish personal gain. So the new SEC's disclosure requires companies to provide daily buyback data. So with the daily buyback data, the investors can identify dates, like the date and here, where the companies bought back stocks in large quantities and derived positive price effect. So, and then with data in mind, the investors can look which directors actually traded their own holdings shortly after the buyback activities. With a positive price effect, the buyback activities and insiders trading come close to one another, the investors would be able to pin down personal benefits that directors derived from the purchase activities. Yeah. No, the daily activity you cannot, because the company is not obligated to disclose that. Well, yeah, filing 220 is this. We're going to talk about Section 220 inspection in just a moment. No, it's just, yeah, it's beyond reach. Okay, so demand futility is really the first hurdle, and in that regard, the SEC's new rules can help. But after passing that hurdle, okay, the investors need to plead a substantive claim, and that is really challenging for the investors because the pleading standard is to plead particularized facts to demonstrate the irrationality of the board's decision to buy back the shares. What is irrationality? That means almost no person of sound mind can conceivably make the same decision. Okay, it's not merely unreasonable, but it's completely irrational, and that the company cannot benefit from the buyback in any way. As you can see, this is a very high, tall order. Investors with shareholders, they were removed from the daily managerial roles of this company. They do not know what opportunities were offered to this company, in addition to perhaps buyback opportunities. They do not know what they do not know the deliberations that occurred in the boardroom. Okay, they do not know how the board decided on the pros and cons of the buyback. So without that information, as the court acknowledged, it is the test to show corporate waste is really difficult for any plaintiff to meet. And then Kate's question, what about Section 220? Section 220 under the Delaware statute allows the shareholders to inspect books and records of the company, but Section 220 right is not absolute. Okay, in order to inspect corporate records for purpose of investigating managerial wrongdoing, you need to have a credible basis, and that in turn requires facts that are above and beyond mere suspicion. Okay, the case that I'm citing here is notorious for denying a shareholder's right. The shareholders was not happy about the enormous amount of compensation given to the top 3 executives of the company while the company wasn't doing well. So basically, the top 3 companies got in the aggregate more than $100 million in compensation. So the shareholder says, well, this may be excessive. It could potentially be a corporate waste. And also I want to see whether this compensation is consistent with each person's job functions as well as their employment contracts. And therefore, the shareholder asked for inspecting corporate records, but the court said, no, you cannot inspect records in this situation because all you have is a suspicion, and suspicion itself is not enough. Okay, so even with the additional daily data the SEC asked the companies to report and all sorts of additional information, I think that provides the investors and the shareholders at most a suspicion of wrongdoing. Okay, and that suspicion is not enough to satisfy the pleading requirements, and it's not even enough to allow the shareholders and investors to access corporate records. So in sum, I do not believe that the SEC's new rules can directly benefit or empower shareholders in their state law claims for fiduciary breach. Note the word I say directly, but perhaps indirectly, that goal can be achieved. That leads to the next issue, federal securities law claims. So in addition to state law claims, there are a few federal securities law claims potentially available. And under Section 10B of the Exchange Act and the corresponding SEC Rule 10b-5. And the law says it's unlawful to employ any scheme, device, and make an immaterial misrepresentation or misleading omission or engage in any act that defrauds or deceives any person. So this is the basic anti-fraud provision of the statute. So under that provision, there are a few potential claims. One is for misrepresentation. And the investors can claim that the management misrepresented their true motives for stock buybacks. They said that they bought back shares because they believed the shares were cheap, or they wanted to neutralize the dilutive effects, but they really intended to benefit themselves. But that part was omitted from the statement. So management misstated the true motives of the buyback. So that's one claim. Or on top of that, the investors can claim that management misrepresented to the public about stock value because they're saying that they bought back the shares because they believe that this is a good opportunity to buy back the shares. But really, they bought back the shares to inflate the market price in order to benefit, for example, their subsequent trading. So those are potentially the misrepresentation claims, and there could be insider trading claims. The theory is that management inflated market price through stock buybacks, and this is a piece of important material non-public information that the stock price is now distorted. And then management later on traded their own holdings based on that material non-public information, thereby violating insider trading regulations. And the next potential claim would be open market manipulation through the sheer force of trading with the sole intent of distorting market price so as to cause the price to deviate from independent path justified by economic fundamentals. That is the definition of market manipulation. So these are the potential federal securities law claims. How can the SEC rules, new rules, help investors with those, for those claims? First of all, misrepresentation about the true motives. Currently, companies are not obligated to report or disclose true motives behind buybacks. Okay, I'm listing two precedents here. In the first case, okay, the management was subject to the pressure from a controlling shareholder who wanted the management to borrow money and buy back shares. If the management refused to do that, the controlling shareholder was going to wage a proxy fight and replace the entire board. So in the end, the management yielded to this pressure and started buying back securities in large quantities. However, in its public release or statements about the motives of these buybacks, the company did not disclose the pressure from the controlling shareholder. It gave some boilerplate statements, something like, we believe right now it's beneficial for us to buy back our shares. Okay. And the shareholder sued for misrepresentation. The court said, management is not liable for hiding their true motives. And similarly, in the second case, the company was subject to the hostile takeover threat. And in order to make it expensive for the corporate wager to accumulate enough companies' shares, the management decided to go into the open market and buy the company's own shares in large quantities, and in the end, was successful in inflating the stock price. And yet the company did not disclose this motive in its statement about the purpose of the buybacks. Again, here the court said the company has no duty to make such a disclosure, therefore shouldn't be held liable for hiding the true motives. And therefore, the SEC's new rules that require companies to disclose their motives in their 10Ks and 10Qs would instill this duty, okay, for management to disclose the true motives. You have the duty now to disclose the true motive. And if you hide the true motives, then you're making material misrepresentation in a document filed with the SEC that triggers liabilities. So this is one concrete benefit that I think the new rules can help investors. Basically, it opens a new avenue for investors to make claims of fraud. Well, the new avenue may be available, but then the investors still need to satisfy the pleading requirement. Here the challenge comes in, because the PSLRA says that to plead a securities fraud case, the plaintiff must specify each statement alleged to have been misleading and the reasons supported by facts why the statement is misleading and facts that give rise to a strong inference of scienter. This is a hurdle that I don't believe that the investors can satisfy, even with the new disclosures mandated by the SEC, because all they have, they don't have a direct or strong circumstantial evidence of management's ulterior motives. All they have is still suspicion. Right. For example, if the claim is that management misstated their true motives because they wanted to inflate stock price in order to benefit their own compensations, then at least the plaintiffs need to show how the executives' compensations are influenced by stock price. Now, you can dig through all public reports made by the companies, and nowhere can you find the mechanism by which the stock price, the disclosure of the mechanism by which the stock price can be influential to executive compensations. There's some broad and vague statements, and like I use Apple's 2024 proxy statement as an example there. The management committee, in discussing Timothy Cook's compensation, it touted the good stock market performance of the company's shares, but nothing more specific beyond that. What about misrepresentation of stock value, right? I think there it's even more difficult for the plaintiffs to be successful, because the PSRA has carved out an explicit exemption for forward-looking statements, as long as you clearly identify that this is a forward-looking statement with embedded cautionary statements, then this statement would be exempt. So when management says that we want to buy back shares because we believe that the shares are underpriced, in essence, it's saying that the shares are underpriced in light of our expected growth opportunities. So that itself is a forward-looking statement. Now, companies in doing buybacks, if the companies are well advised by trained lawyers, they inevitably try to benefit from this exemption. And I'm using the next door's press release for the buyback activities here as an example. This release says, by the way, okay, this release about the stock buyback contains forward-looking statements, including but not limited to statements regarding Nextdoor's share repurchase programs, and then forward-looking statements about our current expectations and projections, objectives, growth opportunities, so on and so forth. As long as companies put a boilerplate statements like that in the press release for the stock repurchase, they will not be sued for misrepresentation about the stock's value. Okay. So I don't think the SEC's new rules can directly benefit investors in their misrepresentation claims. And note again, I say cannot directly, but perhaps indirectly, the new rules could help them. So when I first started, my intuition was very much in alliance with the view of the Chamber of Commerce, and then based on the high pleading requirements and the inability to access corporate records. And I felt like there's no way that the investors can successfully sue the companies in court. And then I changed my mind after looking at insider trading cases. Right? The theory for insider trading is that, again, management knows that the stock price is distorted through buyback activities, and yet later on they disposed of their own holdings while in possession of this material non-public information. Okay, to sue for insider trading, you need to show that management indeed possessed insider information, but then the management intended to trade on that inside information. In Countrywide Finance Corp, shareholders made an insider trading claim against executives who authorized repurchase to allegedly mislead the market and condition the market for selling their own holdings. These top management members indeed sold their own holdings after repurchase. In the end, the court allowed the case to survive summary judgment. Okay, but the court also pointed out the weakness of the plaintiff's claim for insider trading. The court said that shareholders failed to link the specific dates of the repurchase with the dates of insider trades. Okay, the court basically say, I want to see a clearer link between the dates of the repurchase and the dates of the insider trades. However, as you know now, that companies are not required to report their daily repurchase activities. Okay, under the existing rules, the plaintiff in that case could only benefit from the monthly aggregate data. And yet the court said that's a weakness in the plaintiff's claim. Now that leads us to leads to the utility of the daily repurchase data. With the daily repurchase data, the shareholders and investors would indeed be able to identify the dates, the specific dates of the repurchase, and establish a clearer link between those dates and the subsequent executive trading activities. So that is one reason why I think that the SEC's new rules can help investors. And in this case, the plaintiffs survived the summary judgment motion. What about open market activity? Manipulation. First of all, there is actually a split of authority as to whether a company or a person can be liable for market manipulation just through trading alone. Most cases that I examined said that yes, market manipulation activities can be established if the sole intent of the trading is to distort the price. That could be the basis for liability. In Masry, Masry is not a stock repurchase price, but I think it illustrates how the granular data that the SEC mandates in its new regulation would have helped the investors. The SEC sued a few traders for market manipulation. These traders placed consecutive buy orders close to market at the time of market close. And the SEC said that you put in this large quantities of buy orders close to market at the time of market close because you want to push the price up in order to avoid having an option that you have written to be exercised against you, and you do not have the financial capability to honor your obligation under the put options that you have written. So that was the SEC's theory, and the SEC's theory actually was quite weak. The defendants in the case offered fairly plausible explanations for its large quantities of trades. Nonetheless, the court said the SEC has raised sufficiently issue of fact that justify the case to go to trial. And how did the SEC satisfy its standard? Its standard. The SEC showed the timing of the trade. Okay, the dates, in addition to dates, and the specific times of the trades. And the SEC showed the large quantities of the trade, the time of the trades, the large quantities, and showed the price effect of those trades. And the court said these information raised sufficient issue of facts justifying a denial of the defendant's summary judgment motion, allowing basically the case to go to trial. So as you can see, the SEC's new mandate, requiring the companies to disclose daily data, would provide exactly these information to the investors. And with these information in hand, the investors are likely to be able to survive a motion to dismiss and even the summary judgment in their open market manipulation claim. You know what? With the survival of motion to dismiss and summary judgment motion, that opens the door to discovery. And discovery would allow investors to access corporate records that they otherwise wouldn't be able to access. And by looking through the records, they could perhaps find more information that augments their state fiduciary breach claims that they otherwise may fail. And with gathering more information, they could perhaps find evidence that supports their misrepresentation claim that they otherwise would not be able to establish. So therefore, in conclusion, I think the SEC's new enhancement push will indeed bring palpable benefits to investors, empowering the investors in their lawsuits against management for wrongdoing. Okay. This is my presentation, and I welcome questions. I changed my mind in the course of research a couple of times. You know what? If you think I'm wrong, let me know. I may change my mind again.
So did your research ever go into the cost benefits of, opening this to the plaintiff's bar and lots of class actions? Because the new rule looks like it would set the bar pretty low for bringing class actions, and that which ultimately costs, shareholders and consumers.
Well, first of all, the rule, when the bar is already low, as shown from these precedents, right? But the new rules merely equip the investors with the information that they needed to prosecute.
Every day, there's a reporting requirement.
But then the reporting requirements, remember, it's still on a quarterly basis.
Right.
But in this quarterly report, you're providing the daily data. Right, the daily data is already available. The SEC said, look, we do not see any extra burden because the company already has these daily data. In the current reporting requirement, they're adding up, aggregating these daily data or even like, more refined data to come up with a monthly aggregate. Our new regulation simply says you don't have to add them up. All you need to do is to make them available to the public. So what is the extra cost there? But no, it's monthly reporting of daily data. So it's quarterly reporting of daily data. So actually, when the SEC first proposed this rule, it indeed required companies to report on a daily basis. And that requirement, but that proposal was vehemently opposed to by the market, saying that, look, that means we have to hire extra personnel to keep on top of these daily reporting requirement, and that personnel better not be sick on any day, because if he or she is sick, all of a sudden we will violate the rule. And then in the end, the SEC says that we're going to come up with a compromise. Okay, all you need to do is report quarterly. But we believe you can conveniently make the daily data, which is already there, available to the public in the quarter reports.
The business judgment rule would shrink eventually.
That's my question.
I would assume that gives a lot of.
When you say the business judgment rule would shrink, you mean?
Scope of it, meaning I can justify stock buybacks as you kind of walk. Disclose much. Protect what we've decided to do. If I'm now going to lose, let's say if one of the paths we've shown is successful, wouldn't that approach a little bit?
Well, the court is still going to scrutinize, the Delaware court is going to scrutinize the company's decisions based on business judgment. Okay, so it's just that the investors will be able to better satisfy the pleading requirement. I don't think it would have to change.
My question.
Yeah.
What Sean was laying down there, and the reason why I'm going, and also the question from in the back. When you listed the people in support of this rule or institutions in support of this rule, it's the usual suspects of, shareholder litigation. Like I saw AFSCME up there. And so first, my first question is, were they represented by counsel do you know what counsel these folks were represented by, if they were, when they were challenging this rule? Like, are they the usual suspects also in shareholder litigation, first of all? There's no reason why you would know that. I was just curious. And second, I mean, if you're right, and it seems like you are, that this could open up, surviving a motion to dismiss, open up to discovery, and then suddenly we're in court litigating a improper motivations disclosure claim, which will touch upon the proper scope of authority of a board of directors in federal court, maybe by the Fifth Circuit. And so as soon as you're litigating over what motivations were given, you start talking about what motivations are proper. And so my question for you is this like a backdoor way to challenge the business judgment rule, director autonomy in favor of shareholder autonomy, right?
It's not about a substantive
Yeah.
decision of which
Yeah.
motivation is
Yeah.
proper. All you have to do is to disclose the motivation. And you don't have to, the court doesn't have to determine whether that motivation is proper. All the law requires is for you to disclose whichever motive that you had. Thank you.